Welcome, everyone. The secretary will take a silent roll of those in attendance. And first up this morning, we do have minutes to be approved.
Madam Chair, I don't have the dates with me.
Representative Nash.
Yeah, I don't have the dates with me on the minutes. Do we?
Excuse me. Oh, I'm sorry. It is February 23rd.
Thank you, Madam Chair. I move that we approve the minutes for February 23rd for the Judiciary Rules and Administration Committee.
Thank you. You've heard the motion. All in favor say aye. All opposed? Thank you. I'm not seeing Representative Brooke. I think I will move to Representative Nicotia with House Bill 196. Thank you. Welcome, and state your name and where you're from.
Thank you so much, Madam Chair. My name is Lauren Necochea, and I represent District 19, and it is my privilege to bring back fair chance employment to this committee. For years, we have been hearing about the challenges that Idahoans face as they return to their communities from jail or prison. And this bill addresses a significant hurdle for people with a record as they seek employment. I'll give a quick history. A version of this bill passed the Senate last year, and this committee sent it to the amending order to have 2 amendments added that were requested by stakeholders. We hit a snag and never got to a vote on the House floor. The bill before you has those 2 amendments engrossed and one additional change, which I will explain in a bit. It really behooves all of us to make sure that people have a successful transition after they serve their time. When people can connect to employment, everything else, such as securing housing, paying their community supervision fees and restitution, supporting their families or paying child support, and living a crime-free life, is much more likely to be within reach. When people find success after paying their debt to society, our communities are much stronger. We know that 95% of people in Idaho who are sent to prison or jail return to our communities, and they need to be able to access employment. However, we are not achieving the kind of transitions we want. Our state has some of the highest recidivism rates for people who are under community supervision. And in 2019, 76% of those who entered prison were returning, they were coming back. Recidivism is not good for public safety, it's not good for communities or families, and it's not good for our budget. The annual cost to incarcerate an Idahoan is now close to $28,000. And over the past 3 decades, our prison costs have increased at one of the highest rates in the nation, and the cost of business as usual is simply unsustainable. That is where fair chance employment legislation comes in. This policy is straightforward. It removes the initial barriers that people with criminal convictions often face when trying to get a job, delaying that question, do you have a record? And instead allows applicants to demonstrate their skills and experience related to the job in an application rather than never having their application considered. And the bill has 3 main parts. First, job postings could not seek to exclude applicants with criminal backgrounds. Second, job application forms could not question applicants about their criminal background. And third, employers would consider applicants and assess their qualifications before inquiring about their criminal history. Employers would still be able to ask about criminal history, conduct background checks, and make whatever hiring decision is best for them, their business, and the position at hand. However, this gives Idahoans with criminal backgrounds the opportunity to sell their qualifications as opposed to being barred from applying or having their application discarded at the get-go because of a mistake they made and have paid for, and that may have no relevance to the job sought. This bill strikes a balance by preserving business decision autonomy and also asking them not to discriminate at the get-go. We don't define what process or interview the employer must conduct after the initial application review. They can immediately ask about criminal history in whatever next step they take if they so choose. And there are no penalties for employers. The business community was consulted and received education about the bill and had no opposition. And we have a significant number of business endorsements. Fair chance employment hiring principles are not a new concept, and they have been adopted by national corporations such as Walmart, Target, Dave's Killer Bread, and American Airlines, and even local businesses here in Idaho like Albertsons, Hayden Beverage Company, Idaho Power, and CWI have removed criminal history questions from their applications. These companies know that fair chance hiring helps them identify untapped talent and that people with criminal backgrounds have lower rates of turnover and are committed to performing well on the job due to their decreased opportunities in the labor market. Even more, human resource professionals and employment law professionals agree that by adopting fair chance hiring practices, businesses can reduce their legal liability and potential claims of hiring discrimination. Idaho would join 36 other states, including our western neighbors such as Utah and Nevada, that recognize the benefits of getting formerly incarcerated people back into the workforce. Given the current state of our stretched jail and prison systems, fair chance employment is a key tool to reducing recidivism, keeping people with criminal backgrounds away from reincarceration, and providing them the opportunity to gain financial independence, security, and the pride of contributing their productivity to our communities. We know that some positions are subject to criminal background checks due to local, state, or federal law. For example, licensed daycares or law enforcement. Those positions are exempt from the provisions in this bill. The two amendments that we added last year are now engrossed in this bill. One provides that for a 501c3 belonging to a congressionally chartered organization would be exempt, and we added this at the request of the Boys and Girls Club. There's another exemption for master key holder positions as requested by the retailers. We also changed the definition of employer from having more than 5 employees to 20 employees so that it would only apply to larger businesses, and we made that change to demonstrate good faith to a House member of this committee. And I would stress again that there are no penalties for business. One of my priorities as a legislator is to figure out how we can curb our exploding corrections costs. No one wants to spend as much as we are spending, and this is a way to help address that. Just asking that people don't have the door slammed in their face when they go to pursue work. Some of the things that Idahoans need, such as housing, are very costly, and we don't seem to have the appetite to spend a whole bunch more money on that transitional housing. And some of the other things that we might want to look at in criminal justice reform and trying to reduce the number of people incarcerated and the cost of that in any given moment don't seem to be moving quickly through the legislature. I'd encourage you to think about the fact that this is one thing we can do this session to address our prison spending and just some of the other things we might want to do face more significant obstacles. I do want to share, I'll paraphrase one powerful story from last year that a woman in eastern Idaho shared about a young man who was all excited and had a fresh shirt and tie on and a big smile and was ready to go to a job interview at a big plant. And this woman dropped him off and had all the hope for a successful process. This was for a very physically demanding job, and she thought he was going to be well suited to it. And after about 10 minutes, she was surprised to see his number pop up on her phone, and that he was calling her back. And she picked him up, and he was just crestfallen. His whole body was slumped, and he said, "Just take me home." And it turned out that what happened at this facility was that the official in charge just announced to a room full of applicants, if anyone has a record, just leave now because they're not getting hired. And within a month, this young man was using drugs again and was back in the system. And it just begs the question, how could that have been different if he had at least been given a chance to explain the circumstances and have his qualifications considered? So I've shared some troubling statistics about where we are and our growing costs. I'll share a hopeful statistic. If Idahoans with a felony conviction were employed at the same rate as Idahoans overall, we could see an additional $540 million in wages generated annually. For the systemic issues we see in prisoner reentry, I urge your support of House Bill 196. I know you have some powerful testimony awaiting you, and I will be happy to answer any questions now or in my conclusion.
Thank you. Are there any questions right now of Representative Nicosia? If not, we'll move to some of the testimony. Thank you. And before we move along, I am going to say that because we don't have a session this afternoon, I am not going to adhere to the strict adjournment of 2:30. So the subcommittee may be here just a little bit later, but we'll try to move as fast as we can. Thank you. Okay, let's see. Do you have people online? Yes. Let's go to Monet Miller. Okay, Monet, are you online? She's okay. Miss Miller?
Hello. Hi, Chairperson and members of the committee. I'm Monet Miller, and I'm representing the Idaho Coalition Against Sexual and Domestic Violence today. Today, I come in front of you to express our support for House Bill 196. The Idaho Coalition is a member-based organization with the mission of engaging voices to create change in the prevention, intervention, and response to domestic and dating violence and stalking and sexual assault. We know that the economic impacts of criminal records due to post-conviction employment challenges have a direct and adverse impact on families who have experienced domestic violence, and those impacts are related to the continuance of family violence. For example, studies show that when fathers are incarcerated, family income declines by as much as 22%, and 65% of families cannot meet their basic needs. This trend continues upon release. Formerly imprisoned men both work and earn less than those who haven't been incarcerated. This decrease in income post-release is attributable to barriers in employment opportunities due to criminal records. As Lee Goodmark notes in her book, Decriminalizing Domestic Violence, a Balanced Policy Approach, having been incarcerated poses a significant impediment to finding employment for white men and a nearly insurmountable barrier for men of color. As few as 5% of Black men with criminal records receive callbacks for interviews. Families living in these conditions are more likely to experience homelessness, receive public assistance, and live in unsupportive neighborhoods, leaving them in high-stress situations that are correlated to both experiencing and perpetrating domestic violence. In fact, household income level is one of the most, if not the most significant links to future domestic violence in the family. And women who are arrested are likely to have been subjected to abuse and have been physically assaulted, injured, or threatened. If these women are convicted of crimes they were arrested for, they are more likely to be excluded from employment opportunities that allow them the financial means to escape violent relationships and support their children and dependent family members. Often, they are not given a chance to get their foot in the door, even though they may be the most highly qualified for the job. The inability to secure employment relates to the ability to gain safe housing and utilities, which impacts the length of time a woman and her children stay in shelter, and whether or not she returns to an abusive relationship or chooses not to leave the relationship at all. At the Idaho Coalition, we see the impact that exclusionary employment practices have on families. We support the Fair Chance Employment Act because we believe it gives families who experience domestic violence a chance to heal and move beyond the violence that has impacted them the most. The Fair Chance Employment Act will benefit Idaho families, but for that reason, we ask that you support House Bill 196. Thank you.
Thank you, Miss Miller. Are there any questions of Miss Miller? Thank you. We'll take one more online and then we'll do an in-person. Ruby Mendez Mota. Miss Mendez Mota, are you online?
Yes, can you hear me?
We can, thank you. Identify yourself and where you're from.
Wonderful, thank you. Good afternoon, Madam Chair and members of the committee. My name is Ruby Mendez Mota, and I am the campaign strategist with the ACLU of Idaho. And we come here today in support of House Bill 196,
96 that would establish a fair chance employment policy that aims to open the doors for formerly incarcerated Idahoans to access new job opportunities. For a majority of Idahoans on probation and parole, which is an estimated of 21% of residents, finding a job is key to staying out of prison, supporting their families, and rebuilding their lives. Yet it's estimated about half of all applicants who check the box that says they have a criminal record are summarily dismissed without an interview or a chance to explain the circumstances of their conviction. We know that securing and holding employment is imperative to successful reentry, but qualified job-seeking people with records struggle against immense odds to do so. Having a record reduces the likelihood of a job callback or offer by nearly 50% and contributes to high levels of unemployment. Research from the Prison Policy Initiative found that formerly incarcerated individuals experience unemployment at a rate of 4.7% higher than the general population. What this also translates to is a missed opportunity for individuals to not be able to move past their criminal conviction for a debt that has already been paid. This is why we need to start with fair chance. The sole intention of this legislation is it would remove the box from a job application that unfairly restricts job opportunities and encourages the employer to eliminate blanket exclusions of people without record. An employer would be able to ask an applicant at any point about their criminal history after they make a decision about whether their qualifications merit an interview or a conditional offer of employment. This does not eliminate the ability for an employer to conduct a background check or a discussion of their criminal history, nor does it take away their discretion to make the best decision for their business. This will not only benefit our citizens, but businesses that implement fair chance policies will also play an important role in reducing public spending associated with the cycles of reincarceration and expand employment opportunities that will improve spending and economic conditions that are most damaged by mass incarceration. We know that this bill alone will not solve the criminal justice crisis, but it is a good first step and will go a long way in helping those with criminal records to rebuild their lives. So we ask for your support for House Bill 196, and I can stand for any questions.
Thank you. Are there any questions? Representative Young.
Thank you, Madam Chair. And is it Mendez?
Yes.
Excuse me?
Wonderful.
Mendez Malta.
Thank you. I'm just curious. It sounds like some employers are already moving to this kind of system, but obviously others are not, or we would not have this legislation here. I don't see any kind of a penalty associated with the act of asking unfairly about someone's criminal history. Can you help me know what that might look like?
From my understanding, there's no penalty for an individual in this piece of legislation. So there is no consequences, if you will.
Representative Troy.
Thank you, Chairman, and thank you for your testimony. I just was a little confused by, and I'm sorry, I was just getting myself settled in. One of your statements, 21% of our population. I didn't understand population that are in corrections, population
Ms. Mota.
state.
Ms. Mota,
I'm sorry, I could not hear Representative Troy.
go ahead and repeat your question.
So you made a statement early on in your presentation that 21% of our population, and I didn't catch what 21% of that population was.
Ms. Mota.
Yes. Thank you, Madam Chair. Representative Troy, 21% is for those that have already been released or are living with a criminal record. So 1 in 5 Idahoans are living with a criminal record.
Thank you for your testimony. I see no more lights. We will move on to our next witness, Mr. Fred Birnbaum.
Good afternoon, Madam Chair. My name is Fred Birnbaum with the Idaho Freedom Foundation. I think this is a good concept to help people who have criminal convictions, but this is a flawed bill. And I'd like to explain why through the lens of my experience, not my IFF experience, but as an experienced factory manager in my prior life. I ran a plant that packaged blades and razors for Gillette. Some of you might have heard this story last year. We had to hire hundreds of people quickly. under this bill, we couldn't screen these people. And if you've ever purchased razor cartridges, they're very expensive. And in the case of that particular circumstance, we could not hire people with theft convictions. And under this bill, we would have been a business that would have had to have gone through the process, because the bill basically says you don't have to hire people with criminal convictions. You just can't ask them up front. And so I take exception to there's no direct fiscal impact, as this is a policy change for employers. Well, that makes it sound like if we impose something on employers, that doesn't matter. But if you're an employer who does not want to hire someone, this bill says you don't have to, because it says after you don't do these things, you can then, after you make a conditional offer, subject someone to a background check. And then if you have millions of dollars of blades and razors and they have a history of embezzlement, you decide not to hire them, you have to say, gee, I can't hire you. And if you're that person, well, Fred, why did you interview me if you couldn't hire me? Well, sorry, Joe, but I couldn't put that on the application. So you not only do you make the business go through this, but you make them the bad person. The thing that I also don't like about this bill is that it has on page 2 all sorts of carve-outs. Nothing in this section shall prevent an employer from considering an applicant's criminal conviction when making a hiring decision. Okay, so you could do that anyway. Then it says the provisions of this section shall not apply. And it talks about the federal, state, and local law, law enforcement, criminal justice, volunteer, and then the 501c3, and then finally the last one, which makes the least sense, makes the most sense, but really the least sense, 2 positions that are master key holders or keepers of cash. Well, I actually be less worried about the cash in my business than having to hire somebody who had access to the electronic banking records, because I could kind of figure out the cash. So the problem with this bill is that it interposes a decision between the employer and the employee, and it does it in a way which says you really don't have to offer the job in the example that Representative Necochea did. You just have to go through all these hoops, let someone explain themselves, and then if you don't want to hire them because they have a criminal background, then you have to tell them after. In a way, if we feel that these shouldn't be held against people, why would we have all of these exceptions, and why would we say you have to do all these things, but then you still don't have to make the job offer? There's a better way to do this. This bill is flawed. Thank you, and I'll stand for any questions.
Any questions of Mr. Birnbaum?
Thank you. Madam Chairman? Yeah, it's on.
Representative Nate?
Cannon's head is always just lined up perfectly. It's beautiful. All right. Thank you, Madam Chairman. Mr. Birnbaum, I have a question about the exceptions carved out on page 2, specifically A, B, C, and D. You talked about E and F a little bit, but A, B, C, and D. Why do you think they would carve out law enforcement, criminal justice, volunteers, or federal, state, or local employers from this? So apparently they can ask the question up front, but other employers can't. Why do you think they would do that?
Madam Chair, Representative Nate. Well, and I think great question. I think that's what's problematic about the bill. What this bill was, when getting to this point, because this is the second year, they went around and saying, well, how do we get you to sign on? And they didn't want the opposition from the criminal justice system, from law enforcement agencies, and from many federal, state, or local government agencies. So in order to get support for the bill, and obviously the cash piece was added, the 501c3, they said, gee, this bill is a great idea. And these agencies and different units said, well, we like it, but just don't make it apply to us. And I think it's a very important point. If this is such a good idea, I think we all might understand why law enforcement should be exempted. But if you're just a clerk in the criminal justice system, why should that system be exempt from this bill? But if you're going to come work for me and you're going to be more than a clerk, you're going to be my office manager and have access to all my bank records, and I don't really want that. I can't ask that up front, but if you're going to be a clerk in the criminal justice system, they can exclude you. And I think the reason for all these is they were trying to get support or reduce the opposition to this bill, so it's inconsistently applied. I think that's very clear.
Are there further questions? Representative Marshall?
Thank you, Madam Chair. And Mr. Birnbaum, you made the comment that there's a better way. What's the better way?
Madam Chair, Representative Marshall, that's a great question. So I guess what I would say, it's a twofold answer, and this was alluded to earlier. I think businesses that desire should voluntarily do this and be encouraged to. And actually, there are a number of businesses. I'll just speak to my experience. The Idaho Freedom Foundation, we do have one person on our staff, felony. She actually wanted to testify today, but she just couldn't quite make it here. So I think the better response, rather than forcing businesses to go through the process, is to encourage businesses to seek them out. And there are businesses that publicly say, we do hire, and I've known them when I was in the box business. There was a small box plant that actually reached out and hired people who'd been released. And it was kind of heavy work, dirty work. And they told me these people were very grateful. So I think encouraging businesses to do that is a great first step. The other thing that I would add, so this would be my second point, if you wanted to start this process, I would actually say that I would start with a prohibition against government asking these questions rather than imposing on businesses, and see where that goes. And there's other legislation this body has considered where we say government can't contract with someone who discriminates, or government can't do this. That's where I'd start. So if we were going to do legislation, I would actually say, since if we're restricting government from doing something, we would prefer that. So that's the second part. And the first part is, I think, encouraging businesses voluntarily to consider people, and many do, and encouraging more of them, as opposed to forcing them through this process with all sorts of exceptions.
Thank you. Thank you. Seeing no other questions, thank you.
Thank you, Madam Chair.
Alan Reynolds? Good afternoon, Mr. Reynolds. You can
Good afternoon.
tell us
Excuse
who are
me,
you,
my
where you're
patch,
from.
I just had a cataract removed this morning. I am Alan Reynolds. I was born and raised here in Boise, Idaho area. I spent about 9 years and 10 months out south Boise. When I got out, I went trying to look for employment to help pay my way to survive and whatnot. And quite frankly, people wouldn't get back with me. Now, this gentleman here, he has the same reason why. Well, you ever heard of EEOC, the federal government, 1964, discrimination laws? And Title III, which I'm at 73, I come underneath the age. I've been denied employment so many times, and I'm about ready to get hold of EEOC, and Idaho don't like that because they don't want federal government involved in it. But now, like Ruby said, thank heavens, 21% of us were in jails or prison. That's a little over 1/5 of the population of the state of Idaho. That's quite an employment. People that can't get employment and whatnot. Now, if I was lucky, I was able to go on Social Security. I'm surviving, okay. But I worked for Idaho Candy for about 3.5 months. They hired felons right out of jail and whatnot. Then you got CS Meat Packing Plant that hires right out of prison and whatnot. So there's some of these guys, people, women, are extremely good people trying to make up for their mistakes. What if you had your boy or daughter get thrown in jail and they can't get employment? Look at that. But I'm for eliminate that check the box. We just about got through last year or not, except for a couple representatives, you know, like Representative Lopez mentioned, but Idaho's got problems not backing off being hard-headed. I hate to say that because I'm an Idahoan. So I thank you, Madam and gentlemen and ladies, for my opportunity. Thank you.
Thank you, Mr. Reynolds. Are there any questions of Mr. Reynolds? Seeing none, thank you for your testimony.
You're welcome.
Next, we'll go online to David Lund. Mr. Lund, are you there? Mr. Lund?
Yes, here I am. Can you hear me?
Yes, we can hear you. Go ahead and tell us who you are and where you're from. Can you hear us? Can you get him back, or shall we move to the next one and then come back to David? Do you have Evan Stewart? Oh, there he is. Are you on mute, Mr. Lund?
Can you still hear me?
Yes, yes, go ahead.
All right. You've received information from bar none about this legislation, and as you've heard before,
Could you
1 in
identify?
5 Idahoans has a criminal history.
Could you
That's a
identify
number
yourself, Mr.
used
Lund?
by the ACLU of Idaho, as well as the Idaho Freedom Foundation. 21% of adult Idahoans have a criminal history, and chances are that you know someone who this bill is going to affect. It's estimated that there are over 600,000 people in Idaho that are impacted by this bill. I can tell you from my own experience that in order to be successful at reentering society after incarceration, and probably just be successful in life in general, people need housing, transportation, and employment. And the first two of those things rely really heavily on the last. Housing prices are climbing across the state of Idaho, and I think quality employment is more important than it's ever been. Yet Idahoans like me face barriers to employment that make it difficult to obtain work that allows a person to pay for the cost of living these days. This bill is not a silver bullet. It doesn't overhaul Idaho's employment practices to address this problem. It just helps improve the employment environment by providing more opportunities for people with criminal histories to get their feet in the door during the hiring process. In instances where myself or others have had the opportunity to provide background or details about our criminal convictions, employers are willing to set aside their preconceived notions about people like myself who have criminal histories, and they provide us with second chances. This bill encourages employers to do that. Part of me agrees with Mr. Birnbaum. I wish we could get a bill passed that has stronger language than this, but it's just not in the spirit of compromise and collaboration. I think the best part of this bill is the compromise and collaboration that's created it. Every entity had input, including this committee, which provided a lot of feedback last year. Nonprofits, retailers, advocates, and opponents all shaped this bill that's before you today. And this bill, it weighs the freedom of Idaho's employers to make the absolute best decisions for their businesses, and also seeks to return some freedoms to Idahoans with criminal records so they can pursue their best lives. This bill is going to open up opportunities for Idahoans that need them now more than ever, while also leaving the ultimate power to decide with employers. As Representative Young pointed out, this is an aspirational bill. There is no punishment. There is no penalty. I think this bill is the best compromise for all of the stakeholders in this process, and we ask you to please vote in support of this bill. That being said, I stand for questions.
Thank you, Mr. Lund. Are there any questions of Mr. Lund? Seeing no lights, thank you for your testimony. We have Evan Stewart. Mr.
Hi,
Stewart.
can you hear me?
Yes, we can. Would you identify yourself and tell us who you're with?
Yeah, my name is Evan Stewart. I'm the program manager with Jesse Tree.
Go ahead and give us your testimony.
Thank you. As I said, I work at Jesse Tree. It's a nonprofit here in the Treasure Valley. We serve clients in both Ada County and Canyon County. And our bread and butter is really homelessness prevention and preventing evictions from occurring here in those two counties. So I've just got a quick stat from our 2020 data. So we had 1,587 applicants who applied for our emergency rental assistance program, and roughly 30% of those were previously incarcerated or mentioned that they were previously incarcerated. And from our standpoint, that's a pretty significant correlation between being previously incarcerated and housing instability. We have a great case management team. They wanted me to speak on their behalf and address some barriers that they've seen with some of the clients that they've worked with who were previously incarcerated. And some of the biggest ones that we faced are really the employment opportunities, access to resources, and access to housing. It's very difficult when you have that criminal record to get into any housing. The opportunity to apply online and without getting filtered out. So, very much in support of this bill. I'll keep it short and just say that, we do believe that people should have a fair chance to apply for jobs online without being filtered out based on what box they check. So, so that's it for me, and thank you for your time.
Thank you, Mr. Stewart. Are there any questions of Mr. Stewart? Seeing none, we appreciate your testimony. Thank you.
Thank you.
Jason Zimmerman, are you here? Good afternoon, Mr. Zimmerman. It's good to see you again.
Yes, it is.
Tell us who you are and who you represent.
My name is Jason Zimmerman. I am representing myself, and thank you for allowing me to testify today. I was charged in 1994 with involuntary manslaughter and sentenced in 1998 to 25 years. I was given a few chances here and there and failed a couple times and tripped, I guess you could say. However, I was released on October 10th, 2006, and I had gotten a job previous to my release at a granite company. I had approximately about 10 years of granite experience doing countertops, and I would say that I was probably top 2 in that company as far as experience. However, I was the bottom as far as pay. After working there for quite a while, I was promised a raise. That never happened. I finally one day walked out and walked across the street basically to another granite company and was given a fairly considerate raise. In 2008, 2009, the economy kind of started shutting down with the housing market, and there was nobody buying granite. So I was laid off. I got an idea to get my CDL and try to get hired on with the Ada County Highway District. And for 4 years, I applied for every single job that the county had and was never given a call or an interview for any of those positions. The last year of that, I decided I'm going to get hired on as a temp through another agency, and I worked for 8 months as a temp, and all the employees, loved my work. I tried to learn everything that I could, and still could not get an interview. And some of these other guys that were temps as well were getting interviews. They weren't getting hired, but they weren't as well received as I was. And at the last month I was there, I went to one of the directors and I said, hey, I've been really busting my butt trying to get an interview, and I can't. And I can't say whether that was, part of that, as a fact, but I got the next job came open. I got an interview and got the job, and I've been working there ever since, 9 years. And, I've been able to support my kids, and, with this position, I had no problems getting $10 an hour jobs before. I had no problems getting and finding the employment wasn't necessarily the problem. Getting a quality job with benefits and retirement plan was my issue, because they would look at instead of looking at my qualifications, they would look on the fact that I'm a felon. And I just ask that you pass this to the floor. It did pass the Senate last year, and I agree with Mr. Birnbaum. I think that some of that, the writing in there is not necessarily. I think it should be for everyone, even if I
Mr.
wanted to apply
Zimmerman,
for the.
your time's up, I'm sorry.
That's okay.
But thank you. Are
realize
there
that.
any questions of Mr. Zimmerman? Seeing none, thank you so much for
Thank
your
you.
testimony. Kate Haas? Ms. Haas, you tell us who you are and who you represent.
Chairman, members of the committee, my name is Kate Haas with Kestrel West. I'm here today on behalf of the Idaho Alliance of Boys and Girls Clubs. Many of you will remember that I stood up last year and was the odd man out saying that we were not supporting the bill and needed some changes. I'm very pleased to be standing in front of you today, as Representative Nekachia alluded to, and telling you that the bill sponsors were very gracious in working with those of us who had asked for changes. They are incorporated in the bill, and we are happy to support the bill today. This is an important issue. I think the testimony of others shows that it is real and it's something that is impacting Idahoans. On behalf of other clients in many different contexts, we have worked with you guys to reduce barriers to work. And I think that this bill is something that is an important piece of that. We know that research shows that if an individual is able to get back to work after a period of time, I believe it's 3 or 4 years, that individual is no more likely to commit a crime than anyone else in the population. So getting individuals who have been in the system to steady employment is a really, really important way to get them out of the system. So with that, I will stand for questions and ask for your support.
Thank you, Ms. Haas. Are there any questions of Ms. Haas? Representative Amador.
Thank you, Madam Chair. Ms. Haas, I'm just curious, what were the changes that were made that made your client satisfied with the end result?
Ms. Haas?
Chairman, Representative Amador. So the Boys and Girls Club is one of the organizations that's captured in that 501c3 language that Representative Nekachia discussed. And essentially I would think of it akin to the licensed child care facilities, except for most of those, the Boys and Girls Clubs anyway, are not licensed, but very similar situation.
Any other questions of Ms. Haas? Representative Troy?
Yes, thank you, Chairwoman, and Ms. Haas, thank you. So I'm kind of curious, doesn't the Boys and Girls Club, like other organizations that work with youth, have to do background checks on all of their employees to ensure that there's nothing in the background that could be dangerous to those children?
Ms. Haas?
Chairman, Representative Troy, I believe that that is correct. I don't know the exact process of what their hiring process is, but they do have to do those background checks. That's why I draw the analogy to a licensed child care facility. It's a very similar process in terms of hiring and working with children, and there are very specific hiring protocols that the clubs follow that are laid out by the national organization. So those protocols are not necessarily described in law, but they are described by the national organization. And in order for a club to keep their charter with the national organization, they have to follow those protocols.
Do you have a follow-up, Carolyn?
Well, I'm just kind of struggling with, Chairwoman, the connection between a box for organizations that already have to do background checks and 501c3s. It's a pretty big leap for me to understand, and it's a hard bill for me anyway.
Thank you. Are there any other questions?
I have one.
Representative Nate.
Thank you, Madam Chairman. Ms. Haas, following up on Representative Troy's question, background checks aren't free, as I understand it. There's probably costs to doing that. Is that right?
Representative, Ms. Haas.
Chairman, Representative Nate, I believe so.
Okay.
Follow up?
Madam Chairman, follow up. Thank you. Madam
Representative.
Chairman, Ms. Haas. Wouldn't that then really impose an extra cost on, say, a 501c3 that has to do a background check nonetheless, that they go through the hiring process, get to the point of the background check, have to do the background check, pay that cost, only to find out that this person wasn't qualified to work, and it could have been handled in a question right up front that would have saved them a lot of money and time and effort in doing the background check. I mean, doesn't this impose an extraordinary cost on especially 501c3s who are probably operating on donations?
Ms. Haas.
Chairman, Representative Nate, so that's a good clarification, and perhaps I should have been more direct in my testimony. So the language allows for a Boys and Girls Club, for example, to retain that box for the reasons that you've just described. But like all of the things that you described would not be an issue.
Got you. And then one more follow-up.
Follow-up.
Thank you. Thank you, Ms. Haas. I guess so my question then becomes, you can probably anticipate it, that we're carving this out for 501c3s, that they can do the box, but other employers can't, and they may have the same issue. Like I would imagine if I'm a bank and I'm hiring tellers, I wouldn't want to hire a past felon who has been engaging in embezzlement, who was convicted for embezzlement. Shouldn't I be able to ask that up front instead of going through the hiring process, doing a check, and then finding out that, oh, I could have never hired them to begin with?
Ms. Haas.
Chairman, Representative Nate. So the language that's in this particular section of the bill doesn't cover all 501c3s. It is restricted to a subset of 501c3s that are youth-serving organizations like the Boys and Girls Club. And so from our perspective, that's really the driver here, is that it is a youth-serving organization that is also required by a national organization, not by law, but by a national organization to go through a certain set of hiring protocols, including the background checks and those pre-screens, in order for those clubs to be able to keep their charters with the national organization. So for us, that was really the catch, was it wasn't something that's required by law, which would have otherwise been exempted by the bill, but it's still required of our clubs in order for them to be able to be clubs. So we're just kind of stuck, for lack of a better way of saying it. And I'll leave the second half for your question rather than getting out of my lane too much.
Thank you, and thank you for your testimony. Next, we'll have online Jennifer James. Ms. James, are you online?
I am. Can you hear me?
We can hear you. Would you identify yourself and tell us who you represent?
Of course. Thank you, Madam Chair and members of the committee. My name is Jennifer James, and I live in District 18. I am representing myself today as a voting, tax-paying Idaho citizen. I am here to support HB 196 and reducing barriers to employment for previously incarcerated individuals. In the first 4 years post-incarceration, approximately half of all former prisoners are unemployed and report zero earnings. In fact, only 20% of ex-prisoners earn more than $15,000 per year. The barriers for unemployment are extremely high, far higher than an average job seeker faces. It has been researched and documented that the probability of individuals repeating offenses and returning to prison is in part determined by the labor market opportunities they face upon release. Blanket exclusion from job applications reduces the already limited chances that former prisoners have of earning an income that pays better than crime. Current application practices also unfairly target those who have already served their sentences and should have an equal opportunity to rejoin society as a contributing member of the community. HB 196 still provides employers the opportunity to deny applicants based on prior criminal records should they choose, but limits initial biases and prevents blanket exclusions, which in turn gives more opportunities for applicants to be judged based on their current skills, merit, and potential instead of preconceived notions. With over 8,000 people in the state of Idaho incarcerated, an increase of 14% since 2016, and over 17,000 people on parole or probation, it's critical for lawmakers to reduce the potential for repeat offenses by leveling the playing field and giving former prisoners a more equal chance for employment. I urge the committee to vote yes on HB 196. Thank you for hearing my testimony, and I yield for questions.
Thank you, Ms. James. Are there any questions of Ms. James? Seeing none, thank you for your testimony. Next, we'll go to Victoria Koch. Ms. Koch, you're online. Can you hear us?
I can, yes. Can you hear me?
Yes, identify yourself and tell us who you're with.
Perfect. My name is Victoria Coe, and I'm representing myself.
Thank you. Go ahead with your testimony.
Madam Chair and Committee, my name is Victoria Coe. I'm located in Boise, Idaho, and today I'll be sharing my personal testimony as it pertains to House Bill 196. I am the daughter of a convicted felon. My father served his time and is now out on limited supervision parole. As his parole officer says, he is serving a perfect parole, even though his officer and those that support him on a daily basis know his work ethic. Employers have often not given him a fair chance to tell his story or get to know the man he is today. My father is dedicated and a hard worker, and since being out of prison in the last few years, he's worked as a lead supervisor at Chobani for an extended time and is now working as a lead for another company near Twin Falls. His managers hold him in the highest regards and find him to be of irreplaceable value to their team. After he decided to pursue a job with more opportunity for growth, I learned as his daughter how challenging it is for him to get a fair shot at employment. Had he not gone through a temp agency, he likely would not have been considered for a suitable candidate at Chobani because of his background, even though his managers promoted him internally and found him to be such an asset to their team. I helped my father apply for jobs. He's not as internet savvy these days as he once was, so I offered to help him. Disappointingly, many of the places to which he applied counted him out of the running because of one box he had to mark. My father is forever labeled in the eyes of society, and in many situations, such as employment, this label precedes him. It takes away his voice and his fair opportunity to explain his circumstances. People pose the idea that you serve your debt to society in prison, yet when people are released, they continue to pay for their mistakes, regardless of their sentence being completed. An example of this is having to check the box that automatically labels them before their character has been represented, leaving their story untold, and many Americans, including my father, discriminated against. People see felons as hardened criminals, dangerous people, and otherwise distasteful outcasts of our society. But today I challenge you to change the perspective. These people are fathers, mothers, brothers, and sisters. These people are someone's sons or daughters, and I'm sure many people would not stand for their own children to be discriminated against and silenced. I implore you to help these people tell their own story. Help them regain their voice and restore their opportunities. I implore you to vote yes to House Bill 196. I will stand for questions. Thank you.
Thank you, Ms. Koch. Are there any questions of her? Seeing none, thank you so much for your testimony.
Thank you.
Okay, we'll go to Paul Riggins. Is Paul in there? Oh, okay. Andrew Masser? Okay.
Madam Chair and members of the committee, my name is Andrew Master, and I'm a defense attorney from Boise, and I'm here in support of the Fair Chance Employment Act on behalf of the Idaho Association of Criminal Defense Lawyers Legislative Committee. We support the Fair Chance Employment Act because, as criminal defense lawyers, we know the detrimental impact that a criminal conviction can have on job prospects and the dangers posed by the financial stress and instability of unemployment to the efforts of good people to rebuild their lives. The sense of purpose and continuity provided by consistent employment is why our state requires probationers and parolees to have full-time jobs. That's in the standard conditions it's required of everyone. Not only is this sense of purpose key in avoiding recidivism, but as we've heard today, good pay for hard work means that these individuals can meet the various financial costs of a criminal conviction. This bill would allow job applicants to put their best foot forward before consideration of any potential criminal history and has sufficient carve-outs for things like law enforcement or the Boys and Girls Clubs. And as many individuals who have testified have noted, the employers retain full hiring discretion. Our organization supports this legislation because it would allow those with criminal records an opportunity to contribute to our local labor market in a manner that benefits them, their families, our local businesses, and our communities. So with that, I would stand for any questions and ask that you send H-196 to the floor with a due pass recommendation.
Thank you. Is it Masser or Musser?
Masser. It's,
Masser,
yes,
excuse me.
I
Okay.
apologize for the handwriting.
Are there any questions of Mr. Masser? Thank you
Thank you.
so much for your testimony. We'll move to Maddie Stewart online. Miss Stewart, are you online?
Hello.
Hi, go ahead and tell us who you are and who you represent.
Hello, Madam Chair and members of the committee. My name is Maddie Stewart, and I'm representing myself. As a native Idahoan, social work student, employee at the Wasmuth Human Rights Center, and a mother of 4, I feel passionately about fair chance employment for those reentering society post-incarceration. HB 196 enables post-incarcerated Idahoans being able to access employment opportunities, break cycles, and decrease their likelihood of recidivism. HB 196, the Fair Chance Employment Act, not only impacts those who are looking to reenter the workforce post-incarceration to provide for themselves and their loved ones, it impacts Idaho's economy. As it's been mentioned several times already today, 21% of Idahoans have a previous criminal conviction. With the current job application process requiring them to check a box, asking them to disclose their criminal history, is decreasing their chances of getting any callback by more than 50%. I have a family member who has a criminal history and unable to get employment. She desperately wants to be able to be independent and succeed in society as she reenters. However, every time she applies to a job she is qualified for, she never even makes it to the interview. She seems to be excluded from potential employment without even a conversation about her history. There are many reasons that maybe she's not getting these interviews or getting to the second round of the hiring process. However, she seems to meet all the criteria and the schedule availability nearly every time. So it left us all wondering, what if the main barrier is that she has to reveal immediately on the application that she has a criminal history? Giving her a fair chance to show her skills and abilities as an asset to a company is the only way for her employment. And without a job, which has also been mentioned today, how is she supposed to be a contributing member of society? Supporting HB 196 will give her and others the opportunity to have a meaningful employment in our local communities, be able to provide for themselves and loved ones, as well as decrease Idaho's recidivist rates. So members of the committee and Madam Chair, I urge you to vote yes on the HB Fair Chance Employment Act. Thank you. I'll stand for questions.
Thank you, Ms. Stewart. Are there any questions for Ms. Stewart? Seeing none, thank you so much for your testimony. Casey Lang online. She's not there. Okay, we have one last, and I'm going to crucify this name, I'm sure. I think the last name is Bridge. It's not online, in person. Is there a, can you read it? What? No, it's Bridge, isn't it? Schvinn? Okay. Oh, sorry, you wrote that fast, Susie. Welcome, tell us who you are. I'm
Madam
sorry.
Chairman, members of the committee, my apologies for bad handwriting. I was in a little bit of a rush to get here. My name is Suzanne Budge. I'm here on behalf of small and independent employers, the National Federation of Independent Businesses, and I apologize, first of all, to Representative Necochea for not having given her a heads up. I became aware that this was going to have a hearing at about 11 o'clock last night, so I have been scrambling to try and get some information and to coordinate with other business and retail groups Pam Eaton and the Idaho Retailers and Hospitality and Beverage, as you probably have already heard from Pam. She and I work together very frequently on these types of issues. So I'm here today, not in her stead, of course, but because she couldn't be here. National Federation of Independent Business, as you probably know, represents hundreds of thousands of businesses all over the country and 4,500 businesses here in Idaho. Small businesses, in fact, are more than 50% of the employment base in the state of Idaho. And the thing that faces small businesses today is the absolute extraordinary circumstances and the uncertainty of the world we live in right now. And somewhat remarkably related to this bill, the thing we hear most of all from our small business employers is their absolute inability to find and hire qualified workers. So it's really, I think, a challenge to be here today and raise some concerns about this bill, because the very source of employment for a lot of the folks that we would like to see in the workforce are Idaho's small businesses. And many of them would like nothing more than more tools to find more people. But having said that, you have to also recognize that small businesses are not smaller businesses, smaller versions of bigger businesses. Often it's employers, the owners themselves, that are hiring in a small business. They don't have an HR department. They don't have a legal department. And right now their concern is about litigation, liability, and predominantly their company, the safety of their workers, and the safety of their consumers and customers. And so while we very much appreciated the high-minded cause of this and would like to see many more of workers with challenging backgrounds in the workforce, I have to stand here before you on behalf of the employers of the state of Idaho and say this is a concern for them by adding potentially more barriers to hiring. And I understand that the limitation is 20. And maybe if you would give us a carve out too, we'd go to 50 or 100. But frankly, from a policy standpoint, employers need more information, not less. And it's important to match the job with the type of person. And so this comes down to a more individualized decision. But we ballot our members every year. And this was a question on the ballot last year specific to this very issue, and a bill that looked very much like this bill. And our members are very much concerned and show opposition at the level of 91%, which is a pretty high level. We would like nothing more to figure out a better path forward, but adding barriers to employers in their hiring processes is not the way that we think will get us to that point.
Your time's up, but I'm going to
Thank
ask
you,
if there's
Mr.
any
Chairman.
questions.
Thank you, Madam Chairman.
For Ms. Budge. Representative McCrosty.
Thank you. Madam Chairman and Ms. Budge, this kind of becomes challenging because I really do hear your concerns, and it did remind me to go in and to check Pam Eaton's email documenting pretty much everything that you've described for us today. And so there were a couple of recommendations for amendments. If we were to add those amendments, would you and Pam's group, Ms. Eaton's group, be able to support the bill after that?
Ms. Budge?
Should those amendments take place?
Yeah, Madam Chairman, Representative McCrosty, I am digging for Pam's email, which we were sharing. I know that at least one of her proposed amendments was very specific to her industry, and understandably. The other one was, I believe, raising that minimum to 50. And so that certainly is something that would make us more comfortable in terms of making it more targeted to larger companies who have more resources in HR and legal to be able to manage this. So I would say, at least in part, yes. I can't speak for Pam, obviously.
Representative McCrosty.
Thank you, Madam Chairman. Just one more follow-up then. Ms. Budge, because this was a bill that was out there since last year, and I appreciate that this was just brought to your attention. I guess kind of the converse of, we could send it to general orders and make more changes. And then, is there another group that's going to come forward and then say, oh, but now we want some changes too? And there's a, I could see how perhaps the bill sponsor might get real frustrated at, okay, well, here's another one, and here's another one, and here's another exception to make. At what point can we just say, okay, this is the good bill that we go forward with that we can be happy about?
Ms. Budge?
Madam Chairman, Representative McCroskey, absolutely fair points. And the bill has been out there, and bad for me that I didn't pick it up until this late in the process. And I would much have preferred to have worked out with Representative Nekachia, and I have worked on this issue in past. So, there's no good rationale for that. I guess in the larger philosophic basis from the standpoint of small businesses, I guess I would like to see another path forward, which is something more to flip this on the head, more of an incentivized, positive way to get employers to look for niches where this is a good way to support a population that is in need of other alternatives, rather than to put this back on the employer. I am just dramatically empathetic to all the stories we've heard today. We've all, lived through similar stories, and I feel bad even showing up here and raising these issues, but I represent the businesses that hire. And so that's my job today. And with apologies for being late to the party, I appreciate the conversation.
Thank you. Representative Nash.
Thank you, Madam Chair. I'm just curious, Ms. Budge, it was my understanding that the Idaho retailers had some say in the language about master key holders. Is that your understanding of that getting added in there?
Ms. Budge?
Madam Chairman, Representative Nash, I would really prefer to defer some of that to Pam. I'm looking at those exclusions as well, and I wasn't involved in that being included in the language.
Okay, thank you. Representative Troy?
Thank you, Chairwoman. Thank you so much, Ms. Budge, for making it here. If you were to flip it on its head and give incentives, what might that look like?
Madam Chairman, Representative Troy, I have to tell you, I have spent a fair amount of time just trying to get my act together to testify today. And I did run into some information I wanted to explore, but I just haven't had time to do that. I would welcome the opportunity to have those conversations, however.
Follow-up?
Yes, thank you for a follow-up. Ms. Budge, I'm curious, when we talked about this bill last year, I believe one of our recommendations was to start this with our state agencies instead of with business. Do you think that would be a fair way to start a program like this and make sure that our state agencies are a place for opportunities for these folks that certainly are hardworking and need an opportunity without putting that burden on our private businesses?
Ms. Budge?
Madam Chairman, Representative Troy, well, I think that's very consistent with my view of flipping this on its head, which is to provide incentives and targeted areas of the workforce where you don't introduce some of the concerns that you might otherwise, that has been raised by retail and housekeeping and access to financial records, things like that. So yes, I would agree with that.
Representative Troy?
I think just for a comment, I've spent the majority of my career working at state agencies, and I've hired a lot of people in those 20 years. And there's never been a box on any of those state agencies that I've hired for. And so I would think that our state agencies are already close to there. I do appreciate the gentleman's story today about trying to get on with the Ada County Highway District, but I think we're closer to that than we are getting our businesses to be able to do this.
Representative Young?
Thank you, Madam Chair, and thank you, Ms. Budge, for your comment and your indulgence of some of these questions. I guess I don't really have a specific question for you, but I just wanted to thank you for answering these things and I did have just a little concern that maybe we're getting a little off topic when we start asking people to solve the question of what maybe another bill might look like.
Representative Rudke.
Thank you, Madam Chair. Ms. Budge, I don't think there was anything, well, I'm asking you to confirm for me. Is there anything in this legislation that prevents employers from upfront informing potential employees or applicants that the background check will be done, and when it is done, if you're found to have a felony, we can't hire you?
Ms. Budge?
Madam Chairman, Representative Rukti, I don't see that, and I would agree with you. My concern again is that the level, when owners are trying to do their hiring and are limited in terms of the legal and HR resources that larger entities have, that their concern is the potential for a misstep that might put them in legal peril. And so that becomes a level of uncertainty and really just one more layer of complexity to hiring at a time when hiring is really all our small businesses would like to do more of.
Thank you.
Thank you. I see no more lights. Thank you for coming in. Representative Nicochia, we will let you close.
Thank you, Madam Chair and members of the committee. I'll try to clarify a few things that came up in the testimony. This bill is deliberately kind of agnostic about what your process is. And in no way does an employer have to bring in someone from an in-person interview before they ask about criminal history. The point is that you get those applications, you say, here, it looks like there are 5 people here who kind of meet the muster, and then from there on out, whatever you do, then you can start asking, whether that's a one-question phone interview. You know, hi, Joe, I saw your application. I see you have some skills. I do want to know about your criminal history. Okay, we can move forward with that, or we can't. You know, and next applicant, or this looks okay. And you know, there was a question about how, you know, what the background checks cost nonprofits. That's an expense they already have if they're doing background checks, and they can certainly ask about the criminal history before you get to a background check. So this doesn't have any impact on what an employer might spend on a background check. So yeah, just again, you don't have to make, I think it was said that you had to make a conditional offer before asking about criminal history. The way, and it was, you know, some good lawyers, you know, mostly on the Senate side, and we'll make our own decision here on the House side, but it was, you know, lawyers wiser than me who kind of crafted this language about putting in that you could make a conditional offer instead of asking this question in an interview, whether it's online or email, because they didn't want to dictate that that an employer had to have an interview. So the whole purpose is to keep that open. So you don't have to make a conditional offer before asking about criminal history. You don't have to do an in-person interview before asking about criminal history. I suppose we are, you know, I heard both that this should be broader, and then I also heard that we want more amendments and more changes. And so I am definitely, you know, I think we're guilty of having compromised as came up and adding changes that stakeholders want. Folks, I don't think I can get a bill through this legislature without doing that, without compromising. So that's all I'll say about that. Sometimes that's just where we have to go. Moving that requirement of employees from 5 to 20, really the point of that is to make this easier, and so it doesn't raise questions for those small businesses. That was the point of that. And again, there are no penalties for business, but the point is to get people to be able to submit their application and have it considered and not just go immediately into a discard pile. And it's what we need to get our returning citizens back to work. And I guess I'll stand for any questions.
All right, thank you. Representative McCroskey.
Thank you, Madam Chairman and Representative Necochea. On page 2, lines 13 through 18, these are the provisions of this section that shall not apply to A, B, C, and D. Can you set the record straight and tell us why you chose to include these A, B, C, and D on page 2?
Representative Necochea?
So that, so those exemptions are there so that, again, as was mentioned, for example, law enforcement and criminal justice, there will be exclusions. And I guess they want to be upfront that having a criminal record could be an issue with these types of jobs. But it gives, my hope is that the agencies will still give people a chance to explain themselves. And I think with the example of the Boys and Girls Club, they want to be able to retain the ability to say, if you've been convicted of a violent offense, then this is not going to be the place for you to have a job. And so that's why they want to be excluded from this entire section. But I don't think any nonprofit would say that they want to do a blanket exclusion. And that's what's really important, is that an offense from 20 years ago related to substance use disorder should not be a disqualifier for a wide range of positions.
Thank you. Representative Young?
Thank you, Madam Chairman. Representative Necochea. There are a couple of conflicting things that I've heard here, and I'm hoping that you can help me sort this out. So on one hand, we've heard there is no enforcement of this, and then on the other hand, we've heard concerns from business that there will be litigation related to it. Can you help me reconcile those two statements?
Thank you. Yeah. Thank you, Madam Chair. Representative Young. I don't understand where the litigation would come from, honestly. There's no penalty in the law.
Thank you. Are there any other questions? Representative Cannon?
So if somebody applies for a job and a company just blatantly does not follow this law, you don't see the applicant potentially suing the company for not following the law?
Representative Necochea?
Madam Chair, Representative Cannon, I suppose that's a possibility.
Follow-up?
A different question, if I may.
Go ahead.
Thank you, Madam Chair. Representative, I guess I'm having a hard time wrapping my head around this, and it seems to me like obviously there are benefits to the community that we're trying to get back to work and assimilated into society and so forth. And it seems like on the other side there is some cost and efficiency, and it seems like everyone has a problem with it until they're accepted out of it, and then they're fine. Am I missing something, or are we just trying to accept out enough people that we can get this legislation through? And isn't it true that on the side of employers that pretty much everyone is opposed to this until they're accepted out of the requirements?
Representative Necochea?
Madam Chair, Representative Cannon, I would refute that characterization. The amendment we got from the Retailers Association was very specific to master key holder positions, where I think they want to be able to be upfront in their job postings, that's a requirement. They did not have that concern a year ago when this is their language that we put in the bill. They did not have that concern for a wide range. There are a lot of business organizations you don't see here today testifying against this bill. You don't see, for example, the Chambers of Commerce or IACI. Those are organizations that were at the table and who are part of the conversations when this language was negotiated.
Madam Chair, could I just have a point of clarification on leading questions? We're not supposed to ask leading questions, are we?
No. No, I understand. So you do not have to answer that if you choose not to, or you can if you want. Are there any further? Representative Skog?
For discussion and a motion.
First, I'd like to declare Rule 80 as an employer. Declaring a Rule 80 as an employer, for the record.
A Rule 80 will be on the record.
I'm sympathetic with people who find themselves in this situation, getting out of prison and then looking for work, or being convicted and looking for work. And I know a young man in that situation where he can't get that interview that he wants to get. However, I don't like us telling businesses how to interview, and I don't care much for this bill. I think Representative Cannon made a good point about everybody's against it until they get the carve out. So if everybody gets a carve out, I would like one too for my employment. I sometimes employ a little over 20 people at times. I just don't want to be in the business of telling businesses, private businesses, how to do their interview process. I'm okay if we do that for our state government. But so I'll be voting no, or not voting no. I'd ask that we move this, what's the motion? Move to send this to, hold it in committee, this bill.
There's been a motion to hold this bill in committee.
Madam Chair, I'd make, another motion. Substitute motion to send the House Bill 196 to the floor with due pass recommendation.
There is a substitute motion now to send this House Bill 196 to the floor with a due pass recommendation.
And just to speak to the motion.
Go ahead and speak to it.
Madam Chair, I'm not seeing anything in this bill that really creates that many barriers to effectively interviewing applicants for jobs. I have a small business, and my law partner and I decide, we don't want to hire people with felonies or with certain type of felonies. Maybe we just want to be able to ask more questions to find out why they were incarcerated, so we could make a determination as whether we want them to have access to our client information. I think that's perfectly legitimate, and especially for professional business or any type of business where you have those sorts of concerns. But I am not seeing anything in this bill that would prevent you from doing that. You just couldn't have it in the initial application in a box. You could, after you narrowed those applications down and brought people in, you could ask those questions. You could still do and should. We would do a background check on everybody, regardless of whether they indicated that they had served time or not, because you'd be a fool not to. You just check on that stuff. I think the thing I like most about the bill, though, is it forces us to really decide whether we believe in this idea of paying debt to society when we go to prison. When people screw up, when people make mistakes, a good society, I think, expects them to pay that debt to society. Whether that's going to prison or paying a fine or whatever it is, you have to own up to what you did, and society should expect you to do that. What I don't understand is how, even though we expect them to do that, we accept that they have paid their debt to society, we still think it's okay to hang that past act over their head for the rest of their lives. We all love a good redemption story. Shawshank Redemption, The Green Mile, The Longest Yard, that was my favorite growing up. We like the fact that people can make themselves better after having messed up in life. And I think much of it is just because we know that but for the grace of God, could we have gone? We all make mistakes, and sometimes we realize it was the family we were born in that helped us out, the friends that we hung around in, just happenstance, but we could have been in their place. And so we like to believe that people can better themselves, and sometimes they don't. Sometimes they screw up again, and for that, they should pay a debt to society. But giving them a chance to show that they've learned from their mistakes, that they want to do better, that's what society should believe in. That's what we do believe in, I think, and that's what this bill does for us. So I think it's a good bill, and I'd ask that you send it to the floor.
Representative Gannon.
Thank you, Madam Chairman. I just wanted to point out that I don't think that this law would be enforceable without an enforcement mechanism. A good example is in the insurance code, and I was just looking it up to find it, but I think it's 41-1329, which is unfair claims settlement practices. It's been in the code for over 30 years, and it's not enforceable. And it does regulate how claims are supposed to, the conduct of adjusters and disclosures and some other things. And there's never been a way of enforcing because it does not have an enforcement mechanism. So I do think that, at least as far as that issue that came up, I don't think there is an enforcement mechanism in this bill, so I don't think it's going to lead to lawsuits. But I certainly, my good friend from Nampa, he may have seen that section and been frustrated that he couldn't do anything with it either. So, but maybe not, I don't know. But I just want to clarify that particular aspect of this.
Representative Marshall.
Thank you, Madam Chair. So I've been really wrestling with this. I'm just going to express some feelings here. If it doesn't matter to an employer whether a person has a criminal background or not, they're not going to put a box on their application if it doesn't matter. If it does matter to them and they can't put a box on their application, it seems almost meaner to me that someone gets into the process and then is told, well, we're not going to hire you because I have a criminal background check. So the broader question here is, I think people are moving that direction. I think businesses are moving that direction to be more opening to hiring. I'm afraid that the unintended consequence of passing the bill would actually make it a sort of meaner spirited situation where people get into the process. I mean, truly, if it doesn't matter, you're not going to put a box on your application. If it does matter, you're going to stop somebody after they've applied and they've got in the hiring pipeline, then you're going to tell them, well, we're not interested in you. That seems meaner to me than stopping it up front. I'm going to oppose the substitute motion. I don't think we should send this to the floor.
Thank you. Representative Young.
Thank you, Madam Chair. Just a few comments. When I first had the chance to serve on this committee, one of the things that I got to do was to go and watch the pardons and parole process. And there are a few things that trouble me more about our criminal justice system than the single-digit numbers of people who ever receive a pardon in any one year. And I would love to see a change in state policy at some point in time where individuals who have a record but have also shown over a period of time that they have made a change and that they are responsible, contributing citizens would have the chance to have a complete pardon and to be able to walk away from that. Having said that, though, I'm not convinced that this legislation is a step in the right direction. I don't think that it's right for us to pass laws that we're not willing to enforce. And it sounds like there's still some ambiguity here as to whether this actually could be enforced or not. But I think there are only two options. If it truly can't be enforced, then it's not going to change anything. And we ought to leave it alone, especially if we're not willing to enforce it. But if we enact it without any kind of enforcement and people come to expect it, at some point in time, someone will be back before this committee wanting to add an enforcement mechanism. So that leads me to this question. If the entire purpose of the bill is to help people who have been criminalized, why would we create another opportunity to criminalize someone just for asking about someone else's criminal background. It just seems a little counterproductive to me. And I agree wholeheartedly with Representative Cannon's concern about carve-outs. Surely there's someone here that we are failing to carve out because the pattern is clear. Now, when this same issue was before this committee a year ago, the suggestion was made, and I do appreciate the things that, you know, there were some concessions in the past year to try to improve this bill, but the suggestion was made a year ago that this type of legislation could be palatable if it controlled the practice of government hiring. I have much less concern about asking the state of Idaho to employ this practice than I do about asking private employers to make this change. And I don't think that it's fair at all for us as a state government to put a burden on private employers that we are unwilling to bear ourselves. So I will be a no on this legislation.
Thank you. Is there any other discussion on, oh, thank you. Representative Cannon.
Thank you, Madam Chair. I too will be a no on the substitute motion. I have a number of things that I'm kind of struggling with, but they're kind of minor issues as far as the, you know, the enforcement and those kinds of things. Before I went to law school, I graduated undergraduate with a degree in economics, and that's where my real concern lies with this bill, is that we aren't saying that people can't do anything. They can do everything that they can do. If this bill were to pass, they could still do everything that they can do presently. We're just saying that they can't do it efficiently. And to me, if we want to change policy, we ought to just address it and change policy instead of trying to effectuate a change by making inefficiencies in the system. And I think that that's the reality that is manifested by those people who are organized enough and big enough to come in and ask for their carve-out. And I think that the effect would be felt on the employers that aren't big enough and organized enough to come in and ask for their carve-out. And I'm just a proponent for efficiency in the things that we do, and I'll be a no for that reason. Thank you.
Thank you, Representative. Representative Erickson.
So I'm a highly empathetic individual. I work with a lot of people in these circumstances in my career throughout my life. And we highly support finding ways for them to quickly get employment again. But putting limitations, like many of the members of this committee have said, on businesses and local communities is very difficult. We do need to address this issue. This issue needs to be addressed on a high level through policy, like many have spoken. We need to be able to remember the brain science and what happens when people are very young and they make poor decisions. You know, I hire in my line of work people who have had former convictions with drugs, and we interact with youth, right? So we have a lot of safety protocols and practices in place, and background checks and all the things that have been mentioned today for those reasons. But we don't hold people's history against them, because there is a piece of habilitation that takes place. And that's what really the great discussion has been about today. There are so many individuals who've been convicted for poor choices when they're young. The insurance industry has figured this out. Like by age 25, your brain is finally fully developed in most cases. In some cases with us men, a little longer, up to age 30. We hate to admit that, but it's true. And if you look at the neurological science, that's very factual. So the system has not caught up to the science. And so there's a lot of flaws, fundamental flaws that we need to work on another level. And this is a very passionate issue of mine, and I definitely support figuring out ways to get these individuals employed and to not discriminate them on past experiences. But again, there are fundamental flaws in this bill that makes it tougher for businesses to make their own decisions on that, and I cannot limit that as well. And so I would have to vote no on that amendment. Second one.
Seeing no other red lights, we will go to or discussion. We'll go to voting on the substitute motion. Excuse me? A roll call vote on the substitute motion to send to the floor with a due pass.
Representative Kirby. Representative Amador. Representative Scott. Representative Marshall. Representative Troy. Representative Young. Representative Nate. Representative Cannon. Representative Erickson. Representative Skog. Representative Gannon. Representative McCrosty. Representative Rookty. Representative Nash. Sorry, Madam Chair.
Aye. Uh, 10 nay and 5 yeses, and so that motion is defeated. We will now go to the main motion, which is to hold in committee. All those in favor, would you like a roll call on this too? Okay. All those in.
Can I ask for clarification?
Yes.
The motion to hold in committee for time certain or indefinitely? Thank you.
Was it for indefinitely? Yes. This is to hold in committee indefinitely. All those in favor say aye. Aye. All those opposed say nay. Nay. Motion carries. Motion bill will be held. Next, we will move to RS 28734, Representative Green. Representative Green, go ahead and tell us who you are and who you represent.
Thank you, Madam Chair and Committee. My name is Representative Brooke Green. I'm out of Southeast Boise, District 18. Thank you for making the accommodation so I can get up and speak before you. I'm back again, and I want to be clear up front. What is the bill that you have before you? I'm here to introduce RS 28734, but I want to provide some clarification first. The bill does not do the following. This bill does not make target picketing, residential picketing, a misdemeanor. This bill does not limit where speech is to occur. This bill does not prevent someone from standing on someone's sidewalk, street, or adjacent house to express whatever their grievances they necessarily may have. What this bill is a compromise. The bill before you addresses the act of disclosing a person's address or other information identifying the specific location of the individual's residence or dwelling place. This is commonly known as doxing, for the intent to harass, intimidate, or cause another individual to engage in target residential picketing. This act has become more prevalent in our community and unfortunately has played out this past summer on several occasions. Specifically, we saw Meridian police officers' their residents publicly disseminated to encourage residential picketing outside his home. While we've navigated the discussions the last few weeks, there was a lot of communication from law enforcement spouses. I want to highlight one of those communication pieces. As a spouse of law enforcement, a lot of this really does touch close to home. Her name was Amber Abercrombie, and she expressed eloquently the struggles we as law enforcement spouses endure. As spouses and partners of officers, we too are required to sacrifice. We fear for our officers when they put on that badge and when they drive away. We worry endlessly about whether they are safe and pray that they are watched over as they selflessly serve. And we breathe a little sigh of relief when that open the door and they come back in from their long shift. To be asked to extend that worry even after they've returned home is unacceptable. Their homes and their families should be off limits. They protect and they serve. They see the harshest side and the ugliest side of humanity. And routinely, their mental health, and I can attest to this, is taxed. When they shed their duty belts at the end of the day and lock up their weapons, they need to unwind at a place removed from the chaos of that shift. They need to be able to exhale the heaviness of the last 10 plus hours in a safe place, surrounded by their support system and their family. They need to reset. Domestic tranquility is a right, and it's a right afforded to each of us. The bill before you provides that extra level of protection from the increasing act of doxing that is becoming all too familiar. Currently, there is no statute on the book that addresses this very act. Several other states have passed similar legislation. Most notably, the Utah legislature recently passed the same language that is encompassed actually within this bill. In addition to that, Washington, New Jersey, Colorado, Massachusetts, Connecticut have all passed similar or have similar statutes on the book. Target picketing is defined within this bill. However, there is no associated penalty applied for the act of picketing outside one's house. We are addressing the act of intentionally disseminating someone's personal identifying information for the very purpose of harassing and intimidating them. Sheriff Donahue highlighted it best. Legislative officials, law enforcement, we sign on to this work as well, we all know, but the families and the spouses that are home alone at their house become the target. The Fraternal Order of Police, the Chief of Police Association, Sheriff's Association, as well as the prosecutors all support this because they recognize that the threat can unveil itself to the officer's family for simply doing their job. It will become difficult to keep good people in these careers. Their families become victims of this type of behavior. This intimidation is not victimless. The children and spouses, we become captive in our homes. While I recognize this legislation isn't perfect, rather many of us, we don't believe it goes far enough. Well, that's the reality of crafting laws. They're never perfect. But one thing is certain, we did have that discussion. The rich and purposeful discussion about fairness, civil discourse, First Amendment rights, our families, our homes, how we need to protect them. This discussion wasn't one-sided. We heard from people who were deeply hurt by the events of this past year, and we heard from both sides that say we haven't gone far enough, or maybe we went too far. But one thing is certain, this past year gave us a lot to reflect. This legislation doesn't achieve what I wanted, what necessarily our partner agencies wanted, but it does achieve one additional level of security for our families, for our law enforcement officers, for our businesses. As I have mentioned, this legislation is supported by all law enforcement associations throughout Idaho. And I'm asking your support in helping us pass this meaningful legislation to continue and to address the very privacy of protecting our homes and our families from this unfortunate turn of events and this unfortunate behavior and acts that are coming all too familiar within society. With that, I will stand for any questions, and that concludes my introduction.
Representative Nate.
Thank you, Madam Chair. Representative Green. I have a question. I think you made part of it clear in your opening, but this does not make targeted picketing illegal. But I do have two questions as a follow-up to that. Number one, the definition of targeted residential picketing uses the word picketing to define it. So I have a question about that, and I'll save my other for a follow-up.
Thank you, Madam Chair and Representative Neat. No, there is no penalty that is specified or stipulated within the document in front of you. The definition of target picketing is in here because we mention it as an act or an intent that will follow should you disseminate somebody's personal identifying information. But residential target picketing is defined as a reference, and there is no penalty. We heard loud and clear that the behavior of being able to picket out front of someone's home is many people believe a right afforded to them, and we have taken the special steps to address that with this revised legislation in front of you.
Thank you, Madam Chair. Representative Green. Then my question becomes in paragraph 1. This is what's commonly known as doxing, that revealing people's private information. The problem I have with this is in those 5 lines, it says, It's unlawful to publish, post, disseminate, or disclose an individual's residential address or other information identifying the specific location of an individual's residence or dwelling place with the intent to harass, intimidate, or cause another individual to engage in targeted residential picketing. Taking off that last clause after the comma, the prior stuff should make sense. Is it possible to disclose someone's address with the intent to harass? I'm having trouble understanding what it means to disclose somebody's address with the intent to harass or intimidate.
Thank you, Madam Chair. And Representative, I'm going to go ahead and use an example in hopes that maybe that will help answer your question. So this past year, there was 2 incidents. The first incident was a police officer. And when he made the arrest, there were a lot of people who felt that his arrest maybe not necessarily been constitutional. So someone had gone online, had taken his address, posted out there for public, consumption, said, we're going to meet at this location, we're going to protest this officer's behavior. So the very act of putting that information out there for the intention to harass or intimidate, several of us understand what that feels like, and that is the intent. On the flip side, the gal who was arrested, and many people felt that her arrest was unconstitutional, someone else went, took her address, posted and disseminated online and said, we're all going to congregate and we're going to go and protest that woman's who was arrested, as her behavior apparently they thought was not appropriate. The act of putting that information out there to encourage people to assemble in front of that person's house for the intention to intimidate or harass, which is something we all can understand what that feels like, is what we're looking to address. It's the act of disseminating it for the very purpose for somebody to feel trapped or uncomfortable in their home as a result of that behavior. So this really does take care of everyone across the board. It's the dissemination of information for the very purpose to intimidate, harass, or result in target picketing.
Okay, Madam Chair, one more follow-up. Okay. Madam Chair, Representative Green, so if I'm upset with a public official or officer or anyone who I want to go and just demonstrate in front of their house, if I mention to my wife, hey, I'm going here, it's on 123 Main Street, meet me there, I have just violated this law.
Thank you, Madam Chair and Representative. It would have to be actually prosecutable before our prosecutors, our law enforcement are going to pursue it. So they need an abundance of information, an abundance of evidence that you actually had done that. What was obvious and what we've seen several times, and you guys just recently, a couple of weeks ago, the act of putting somebody's address and a time and location for the very purpose of showing up and picketing their house was the act that we're trying to address. So through side conversation, that is not going to be enough for a prosecutor or sheriff or a law enforcement officer to actually prosecute for that. But it was clear the behaviors that we saw unfold this past year in several occasions, they could look back at that and say, yes, there is enough evidence that is presented to us. We feel comfortable in making that arrest or making that citation and therefore taking it to court. That's the case with almost all laws on the book. You need an abundance of evidence to be able to prosecute, or they're not going to pursue it. So while we recognize the act of people showing up on their doorsteps and pulling them all together and ticketing them because they're physically there might be a little easier to discern, this is a abundance of evidence that will be necessary for a prosecutor, sheriff, or a law enforcement officer to feel that they can actually cite with that misdemeanor.
Representative Scott.
Thank you, Madam Chairman. Representative Green, can you just clarify, so it is legal to go picket in front of someone's house or protest in front of someone's house currently and would be with this law still? Is that correct?
Representative.
Madam Chair and Representative Scott, it is not illegal in the state of Ohio currently to go and picket in front of someone's homes. This law does not change that.
Okay, thank you. So I'm having problems with how this is written then, because if I have a problem with Representative Nate and I want to go picket his house or get my friends and say he voted poorly and we need to at least let him know we're aware of this. And so I go to my Facebook and say, show up at 123 Main Street let's go picket and show him how we feel about this. And so I put that out there. My intent is to just picket and show him we disagree with his vote. And so how does a police officer know your intent? And if you put that out there, and let's just say some bad actors show up and cause a problem, but I've put the address out, am I responsible for their bad behavior then?
Representative.
Madam Chair and Representative Scott, the act of taking Representative Nate's address, posting it on Facebook for the very intention of intimidating, harassing, or target picketing, that act would be considered a misdemeanor according to this. Now, should somebody show up and they disrupt the tranquility of that home at whatever level, whatever laws are on the books would be the ones to address that. But the act of doxing somebody's information for the very purpose of intimidation or harassment or target picketing would constitute a misdemeanor according to this.
A quick follow-up. Thank you, Madam Chair. Representative Green, so how would I let people know where we're going to go do our protest? Because it's going to be illegal now, correct?
Madam Chair, Representative Scott, you can communicate in a means that you feel comfortable, but should you disseminate that information publicly for the very intentions outlined within the stipulated lines within this, then that would constitute a misdemeanor. The act of picketing out front of somebody's house is not, under any circumstances, under current law, a misdemeanor, or there's not a infraction associated with that.
Okay. Representative Gannon.
Oh, thank you, Madam Chair. I was just going to object to Representative Scott's statement that if she were to picket Representative Nate's house, because I think it's a lot more likely that I would picket his house, not her. So, but I probably would not picket at all.
Point duly noted. Representative McCrosty.
Madam Chairman, for a motion.
Go ahead.
I move to introduce RS 28734.
There's been a motion on the table to introduce RS 28734. Discussion?
Madam Chair,
Yes.
I still have a
Representative
question.
Young.
Yes, for Representative Green, if I may.
Yes.
So all of the emotions and the scenarios aside, I would just like to drill down on what we're doing definitionally here in this piece of legislation. So we have a definition for targeted residential picketing. And the verbs that I see here that define targeted residential picketing are engaging in, actually engaging is the verb, so we're engaging in picketing or other demonstration. I still don't know what picketing is. There's no legal definition of picketing anywhere that I'm aware of in state code. And if there was, the terms other demonstration would still leave this incredibly vague. So I'm not sure how I know what targeted residential picketing is. Can you point me to some language or a definition somewhere in state code that would clear that up for me?
Madam Chair and Representative Young, the definition that you see in front of us is the definition that we are putting into state code. Currently, there is no definition of picketing as it pertains to current statutes. The language that we are using that's within this statute in front of you is the exact same language that we have taken from the Arizona statute that's been on the books since 1995, and that has been upheld. So we are pretty comfortable and confident with what's put in front of you as being what it is constitutional. Again, I do want to reiterate, you can picket in front of somebody's house as much as you want. That is not what we are citing here. We are citing the very act of doxing somebody's information for the very purpose of harassment, intimidation, or picketing their home.
Madam Chair, if I may, I didn't really hear the answer to my question. May I try again?
Certainly.
Thank you, Madam Chair. What I am looking for is a definition of picketing, because you can't define picketing by saying it's picketing without defining picketing.
Madam Chair?
Madam Chair,
Yes. Who's Madam Chair?
It's- the way a court would look at that is they just look at the dictionary definition of picketing.
That's
We,
right.
we don't have to define everything. If it isn't defined in code, then a court will just look to the dictionary definition of picketing if it needs assistance.
Thank you.
I hate to get caught up, or
Okay.
wrapped around the axle on this.
I do too. Thank you, Representative Rudke. Representative Marshall, you're next.
Well, I was just going to help clarify that. The definition of picketing in the dictionary, and I agree totally with Representative Rudke on this, we don't define everything in code. When it's a common word that's used and it's definable, and so a person or group of people standing outside a place of work or other venue, protesting something or trying to persuade, that's picketing. And it's pretty straightforward.
Thank you. Representative Kirby,
Yeah, Madam Chair, for a substitute motion.
go ahead.
So, Madam Chair, I'd move to send this RS to the floor to the second reading calendar, and I'd like to explain my motion.
Please, go ahead.
Yeah, so this is a good discussion, but I think to be fair to this is a pretty well-known issue. This is a redundant deal, and I think it deserves a discussion on the floor. And if we don't get it to the floor today, if we don't send it up there, it has no chance of making it up there by the transmission date. So not sending it to the floor today is effectively killing the bill. So I just think there's a lot of discussion here, and that would be a great discussion to have on the floor, and then it makes it or dies up there with everyone having a shot at it and a good discussion. And we've kind of finished the discussion we didn't quite have on the floor after getting, 150 emails or whatever.
Thank you. Representative Scott.
Thank you, Madam Chair. Just a question. Representative Green, I'm curious. So I know everything from Boise eyes is through the city, but let's just say I have a piece of property and it borders state land or Forest Service land, and I have picketers outside that decide they want to line my property. Am I going to be covered under this? Because it says, what does it say here? In front of, on the street or sidewalk in front of a person's residence or dwelling place, or in the street or sidewalk in front of the adjacent resident or dwelling place. Now, I've got a lot of open space and not a lot of zero sidewalks and one main road, but I'm off the road. So what does that look like? Would I be covered under this?
Madam Chair and Representative Scott, I know we can go down several hypotheticals as we try to discern what is protected or not. Apparently, my initial reaction or response to that would be, you're covered. If anybody were to go picket on your property or the adjacent property, they have the right, not on your property, but they have the right to certainly picket out in front of your property or the adjacent property, or however on the private forest land. The act of them disseminating your address to get people to assemble in front of your property, that act is what we consider doxing, and that would make the misdemeanor.
Quick follow-up. Thank you, Madam Chair and Representative Green. So could they say, show up at Forest Service spot, campground, could they give the address right next to mine? But they're picketing me? Would it cover it? Would this language cover it?
Madam Chair and Representative Scott, that would be something I'd have to look into.
Thank you. Representative McCrosty.
Madam Chair, I didn't want to jump in line ahead of Representatives Nate or Young, but I just want to say that I support the substitute motion. I'm going to leave my underlying motion out there in case that doesn't pass, but I think it's a good one.
Thank you. Representative Young.
Thank you, Madam Chair. I would appreciate maybe some additional clarification too in this definition. And you may remember I was a no on this language the first time because of definitional problems in part. So with the idea in mind that this isn't just a statute that applies to elected officials or police officers, that this statute is a blanket statute, applies to every Idahoan equally. I see the term person a couple of times here. And it's illegal to picket or otherwise demonstrate in front of a person's home for the purpose of, with intent to harass, annoy, or alarm another person. But to me, that language almost indicates that the person whose home you are in front of is not necessarily the person that you annoy or alarm. Can you help resolve that for me?
Representative.
Madam Chair and Representative, I'm not exactly sure how to give the appropriate response. Certainly, we took this language and mimicked it off of already existing state statute for that reason. That has been upheld. Person being what we were suggested as being as the party in which we're trying to protect from this egregious behavior. Certainly, if you're out picketing in front of somebody's home, you're also disturbing probably their neighbors. You're disturbing everybody in the neighborhood. Although, back to the intent of what is in front of you, the intent of this, what we are putting forward as your RS, is not to criminalize the behavior of picketing. It is to address the behavior of doxing somebody's personal identifying information for the very purpose to intimidate and to harass or target picketing. And should you show up and assemble in front of somebody's home, that is still legal in the state of Idaho. And when this passes, will still be legal once this passes.
Thank you. Do we have one more light on? Representative Nate?
Thank you, Madam Chair.
Can we have just a question?
I'm speaking to the motion, the substitute motion. Okay. And I would oppose the substitute motion and oppose the main motion because I think this bill has, or this proposed RS has serious problems. It is not the same as we've already hashed. The prior one, as the good sponsor indicated, was about targeted picketing. This is not about targeted picketing. This is apparently about organizing targeted picketing and organizing assembly and speech. It seems to me to be touching two First Amendment issues and causing constraints on both of those. The idea of publishing, posting, or disseminating sounds reasonable, but then or disclose an individual's. Disclosing could mean me mentioning it to somebody or saying it to someone, saying, hey, we're going to go and picket, which is something totally legal, apparently now. We can go and picket somebody's house. They say, oh, great, where? And if I say the address, I've violated this law because that's disclosing. It's not just publishing, as this states, it's also disclosing. Also, beyond that, too, is that what if I disclose that address, not with the intent to harass or intimidate, but to just organize a picketing? Well, when that picketing happens, then the officer has to determine whether it qualifies as targeted picketing and whether or not my disclosure of that address caused that to happen. And targeted picketing, apparently from this, rests on the intent of the individuals. The disclosure language also rests on my intent to disclose, to harm, harass, annoy, harass, or cause targeted picketing. So this is almost legislating an intent of an intent. And I don't even know how we get the first intent determined in law, let alone an intent of an intent. So I have real problems with this, and so I would say, you know, I'm against both motions, and I'll be voting that way. Thank you.
Representative Marshall.
Thank you, Madam Chair. I think the definitions in here are sufficiently clear that any reasonable person who has a legal mind or an unlegal mind can understand it. I don't have any problem with the definitions that are here. We can nitpick definitions incessantly, but these definitions are sufficiently tight. There's another broader issue here that all of this has raised. Our First Amendment rights are not absolute. We've always understood that First Amendment rights, the right to speech, the right to assemble, they all have certain limits to them. We can't slander people, and we can't threaten personal harm or assault people in that way. That's not part of our right to speech. I think it's wrong, just flat out wrong, to picket in front of a residential home. It's wrong, and people should know it's wrong, and people shouldn't do it. They just shouldn't do it because it's wrong. In our society, if we want to be free, most restraint on our behavior has to be self-imposed. If that restraint is not self-imposed, then we're going to ask government to pass more and more law until the laws become numerous and oppressive, and none of us want that. But there has to be a balance here. Freedom requires a balance, and it requires restraint. Picketing in front of a residential property is wrong, and it ought not to be. Now, if the people of this state insist on their right to picket in front of a residential home, then we'll have to make it wrong in statute. That's what we'll have to do. I hope that the people of this state would be wise enough to know it's just flat out wrong. It is not protected speech. It is not protected right to assemble, to harass people in that sacred space of their property and their home. That is not right. They can come down here and picket all they want. They can come to any public meeting and picket all they want. But they do not have the right, under speech and assembly, to come and harass me in that sacred space that is my home. The Third and Fourth Amendment to the Constitution of the United States enshrines a certain right of privacy in our homes, our persons, and our effects. So I think that's a broader issue. And I wish everybody in the sound of my voice would listen. If you persist on doing things that are inherently wrong, although not illegal, then eventually the state will have to make them illegal. If that's what you want to just
Madam
have us
Chair.
force us, if you just want to force us to
Madam
keep
Chair, I
making,
think we need to
if you
speak
want
to
to
the
force
issue
us to
and
keep
not to
making
people.
laws, because we have to say to some people, that's wrong, then that's what we'll have to do. I'll vote for the motion to send it to the second reading.
Thank you. Representative Brudke.
Madam Chair, amen to that.
Representative Scott.
Thank you, Madam Chair. I have concerns sending this to the second reading. I do think it is a really hot topic. I think what we discussed before is not exactly the same issue. To disclose information is different than picketing. And if we're not really having the picketing thing, we're talking about disclosing information. And it is a First Amendment right, and I think it's something that's worthy to look into. And that's why I will not be supporting to send this to the second reading. I don't know how I feel exactly on the bill itself. I do think the language is vague once again, and it needs some cleanup, but to just not have a hearing on such a controversial bill that has already caused so much conflict with citizens and with the chairman, I just think it would be worth doing a hearing and actually hearing both sides on this issue.
Representative Cannons, how many times do you have a lot that you want to add to this
Do
topic?
I have a lot? Are you asking me?
No, I'm asking the two behind you, but I do want you to speak first, Representative Cannon. I'm just looking at the clock. Thank you.
Thank you, Madam Chair. I will be supporting the substitute motion made by Representative Kirby. I want to speak to the intent element of this proposed legislation and indicate that this is not unique. If you were to study Title 18 of the Idaho Code, which sets forth a majority of the crimes that are defined in Idaho, you would find that title replete with laws that have a certain intent element to them, and most of them are very difficult to determine, and that's just the nature of the criminal law system in America. In law school, we learn that a crime is an act or an actus reus combined with a certain criminal intent called a mens rea, and that criminal intent is often super hard to determine, but that doesn't mean we can't define it in a code and try to do so. And if it's hard to do so, it probably means, in a given case, if it's hard to do so, it probably means that it won't result in a prosecution. But if it's easy to determine, in other words, if you've got a social media post that says, this guy's a jerk, let's go make noise, let's go have our pitchforks, let's go cause a commotion and make it so he can't sleep tonight, then that makes it easy to determine that criminal intent, and that's the kind of case that's going to result in a prosecution under this law. I think it's a good law. I think it's one worth debating in front of the full House, and I will be supporting Representative Kirby's substitute motion.
Thank you. Representative Young, for a quick response.
Thank you, Madam Chair. You know, I thought I was done, but I do feel like I would like to just clarify that in opposing the motions, I am not in any way advocating for the idea that it's okay to harass or to threaten people. And I believe that the behaviors, which we all agree are abhorrent, are contained in our Disturbing the Peace statute. Behaviors including making loud and unusual noise, tumultuous or offensive conduct, threatening, quarreling, challenging to fight or fighting, or, and I understand this is unenforceable, using any vulgar, profane, or indecent language within the presence or hearing of children. I am not in any way suggesting that these kinds of behaviors are appropriate, but I am very uncomfortable with criminalizing something that I can't understand what it is, because when I read the definitions in Disturbing the Peace, to me, all that's left is someone standing silently on a street or a sidewalk. And I'm not ready to make that something that's illegal. And so I just wanted to make sure that we stay on base here in terms of what really is the difference between passing this or not passing it.
Thank you. Representative Nate.
Thank you, Madam Chair. Just quickly, I've had a change of heart, at least on part of this, and that is that I will be opposing the motion to the substitute motion to send it to the floor to the second reading, but I will support a motion to introduce it, because I do think a full hearing is in order when this is, as detailed by the sponsor, a different issue. It's not dealing with targeted picketing. It's not making that illegal like the first bill did. This is making the disclosure of residential address information for that intent illegal. And I would like to hear from some experts. I would like to hear from other lawyers, maybe, you know, that could go into that and really speak to the constitutionality of it and to the parameters of it and to what disclosure means here and how, you know, how much we can limit disclosure in people's speech in that way. So I want to hear that. And also I'll just finish by saying if Representative Gannon wants to demonstrate in front of my home, I welcome him. I've never had a demonstrator. If I did, I'd probably bring him hot cocoa and talk to him. But anyway, I welcome that. Thanks.
Thank you. And seeing no further lights, I think we will vote.
I'd like a roll call, please. Just a roll call, that's all.
Roll call vote on the amended order, substitute order, excuse me. It's been a long afternoon, hasn't it, for RS 28734 to send to the floor on the second reading. Please. All those in favor, no, I'm sorry, roll call vote. You know what to say.
Representative Kirby. Representative Amador's not here. Representative Scott. Representative Marshall. Representative Troy. Representative Young. Representative Nate. Representative Cannon. Representative Erickson. Representative Gannon. Representative McCrosty. Representative Ruckty. Representative Nash. Madam Chair.
Aye. Ten ayes, 3 nays. It will be sent to the floor on second reading. Thank you so much, Representative. Before we adjourn, I will try to find another day to do the substitute committee, the subcommittee, excuse me, because we've lost a couple people here, and I don't believe we would have a quorum. But the chairman has sent a letter, and I'm assuming that perhaps the people on the subcommittee received it too. We will have Senate Bill 1088 as amended also on there. And I don't think it's under the same time restraints. And so we will, if we can set this up for, is today Wednesday? Friday, possibly. It probably won't take nearly as long as today. And then we have to have a discussion on the House Bill 45. So with that,
Madam Chair?
We will be adjourned for today.
Madam Chair,
Yes. Excuse me.
I just wondered if you know if Chairman Cheney is planning to call a meeting on Friday.
I don't know that he's planning to call a meeting on Friday, do you?
Could we just express to him that if there's any meeting on Friday, it be immediately following?
If we
the
do
floor?
one, we'll express that, and if not, we will do one, we will have it following.
Yeah, thank you.
All right, thank you.